Hi everyone, my name is Shazia Khan, and today's unit that we'll be looking at is contract law, and the learning outcome we'll be looking at is learning outcome 7, which is to understand the legal issue of damages. We looked at learning outcome 6 previously, which was to understand the legal issues of duress and undue influence, and we looked at this with reference to legal cases and also with reference to examples, and we looked at economic duress, and we looked at the issue of where a person is actually forced to sign a contract. So with reference to cases, now we're going to look at understanding the legal issue of damages. So the learning outcome is to explain the concept of remoteness and measurement of damages. Damages are awarded for breach of contract. Generally, the purpose of an award for breach of contract is to compensate the injured party. The general rule is that damages are meant to place the claimant in the same position as if the contract had been performed. Damages are usually awarded for expenditure loss, which is loss of bargain, or reliance loss, which is wasted expenditure. In some cases, the court may award damages which go beyond a strict measure of compensation. Damages in contract law, as we've explained, is a legal remedy available for breach of contract. Damages are an award of money to compensate the innocent party, and the primary purpose of damages in contract law is to place the injured party in the position they have been in had the contract been performed. The case of Photo Production Limited and Securico Transport Limited 1980 explained the basis of the remedy of damages, and Lord Diplock in this case identified two different types of damages. Firstly, he identified compensatory damages and then non-compensatory damages, and we'll be going through each one so it's clear that you know which one deals with what. Firstly, compensatory damages are an award of sum of money which aims to compensate the claimant for his loss under the contract. This need not be limited to loss from the contract itself and may compensate the innocent party for losses related to subsequent contracts. Compensatory damages, in order to assess whether an innocent party may be entitled to damages, there are 6 things that should be considered. Firstly, has the claimant suffered any loss? Secondly, is the loss suffered actionable? Thirdly, did the breach of contract cause the loss? Fourthly, was the type of loss reasonably foreseeable? Fifth, did the claimant mitigate the loss? And number 6, did the claimant contribute to the loss? The first step to ascertain the loss the claimant has suffered under the contract. The general rule is that the claimant may only recover for his own loss, as in the case of Alfred McAlpine Construction Limited and Panatone Limited, 2001. The claimant does not need to be able to identify an exact amount of loss. The fact there is a loss at all is sufficient to satisfy the first requirement. The courts will attempt to quantify the loss no matter the difficulty. The case in regards to this that we're going to look at in more detail is the case of Chaplin and Hicks, 1911. And in this case, the claimant was a finalist in a competition along with 50 other people. The prize was a job as an actress. Each finalist was to book an appointment to have an opportunity to showcase their skills. The defendant did not allow the claimant to have an appointment and therefore missed out on the opportunity to win the competition. The court held that the defendant had breached the contract with the claimant by not giving her a fair opportunity to participate in the contract. The court awarded damages despite the difficulty in calculating the value of her lost opportunity. The court was happy to award damages on the basis. The case of Chaplin and Hicks brings us onto an important rule relating to loss. In that case, there was no tangible loss as such. It was a loss of opportunity. The loss of an opportunity can only amount to an actionable loss where it is the actions of the third party which determine whether the claimant would have made a gain. Another case to look at is the case of Allied Maples Group Limited and Simmons 1995. In this case, the claimant need only show that there was a speculative chance that they would have made the gain. It does not need to be likelihood or certainty assessing this rule in relation to Chaplin and Hicks. The third party in that case was the panel of judges who would decide the winners of the competition, whereas the contracting party did not determine the gain of the claimant. They were only required to arrange an appointment. And examples of non-compensatory damages. So we've got nominal damages, aggrieved, aggravated damages, restitutionary damages, and accounts of profits. Damages for breach of contract are subject to the principle of remoteness, causation, and mitigation. Remoteness. The term remoteness refers to the legal test of causation, which is used when determining the types of loss caused by a breach of contract or a duty which may be compensated by a damages award. Causation referred to the inquiry as to whether the defendant's conduct was caused a harm or a damage. Legal causation is different from factual causation, which we've explained earlier, which raises the question whether the damage resulted from the breach of contract or duty. Accordingly, once factual causation is established, it is necessary to ask whether the law is prepared to attribute the damage to the particular breach, notwithstanding the factual connection. Damage which is too remote is not recoverable, even if there is a factual link between the breach of contract or duty and loss. So remoteness of damage, as we mentioned, relates to the requirement that the damage must be of foreseeable type. In negligence claims, once the claim has established that the defendant owes him a duty of care and is in breach of that duty, which has caused damage, they must also demonstrate that the damage was not too remote. Remoteness of damage must also be applied to claims under Occupiers Liabilities Act and also Nuisance Act claims. Remoteness is often viewed as an additional mechanism of controlling tortious liability. Not every loss will be recoverable. Originally, defendant was liable for losses which were a direct consequence of the defendant's breach of duty. An important case in regards to this in remoteness is the case of R and Polymus and Furnace Withy and Company Limited, 1921. In this case, some stevedore's carelessness dropped a plank of wood into the hold of a ship. The plank struck something as it was falling, which caused a spark. The spark was ignited by petrol vapours, resulting in the destruction of the ship. The arbitrator held that the causing of the spark could not have been anticipated, and therefore the liability arose. The claimant appealed. It was held that there was no requirement that the damages were foreseeable. The defendant was liable for all the direct consequences of their actions. And the next important case in regards to this is the Wagon Mound case. And in this case, the defendant's vessel, the Wagon Mound, leaked furnace oil at a wharf in Sydney Harbour. Some cotton debris became embroiled in the oil, and sparks from some welding works ignited the oil. The fire spread rapidly, causing destruction of some boats and the wharf. And it was held that the case of Polymus should no longer be regarded as good law. A test of remoteness of damage was substituted for the direct consequence test. The test is whether the damage is of a kind that was foreseeable. If a foreseeable damage is present, the defendant is liable for the extent of the damage, no matter whether the extent of the damage was foreseeable. Following the Wagamond case, the test for remoteness of damage is that the damage must be of a kind which was foreseeable. Once the damage is of a kind that is foreseeable, the defendant is liable for the full extent of the damage, no matter whether the extent of the damage is foreseeable. The Wagamond test was considered and applied in another case of Hughes and Lord Advocate, 1963. It was a House of Lords case. In this case, two boys aged 8 and 10 went exploring an unattended manhole. The manhole had been left by workmen taking a break. It was surrounded by a tent, and some paraffin lamps were left to warn road users of the danger. The boys took a lamp down the hole. One of them dropped the lamp and an unforeseeable explosion occurred, resulting in extensive burns. It was held that the damage was not too remote. It was foreseeable that the boys may suffer a burn from the lamp. The fact that the burn resulted from an unforeseeable explosion did not prevent the type of damage being foreseeable. Under the rules of remoteness of damage in contract law, in the case of Hadley and Baxendale, a claimant may only recover losses which may be reasonable to be considered as arising naturally from the breach, or those may be reasonable, be supposed to be in the contemplation of the parties at the times of the contract was made. In this case, the Hadley and Baxendale, the craft ship broke in the claimant's mill. He engaged the services of the defendant to deliver the craft shaft to the place where it was to be repaired and to subsequently return it after it had been repaired. Due to the negligence of the defendant, the craft shaft was returned 7 days late. The claimant was unable to use the mill during the time and claimed for loss of profit. The defendant argued that he was unaware that the mill would have had been closed during the delay, therefore the loss of profit was too remote. It was held that the damages available for breach of contract include those which may fairly and reasonably be considered arising naturally from the breach of contract, or number two, such damages as may reasonable to be supposed to have been in the contemplation of both the parties at the time of the contract was made. Another important case in regards to the remoteness was the case of Pilkington and Woods, 1953. In this case, the claimant purchased a house which turned out to have a defective title. Shortly after the purchase, he obtained employment elsewhere and needed to relocate. He had difficulty in selling the house due to the defect in the title deeds. He brought an action against his solicitor for negligence in failing to notice the defect. It was held in this case that the solicitor was liable for the difference in value between what it was worth without the defect and what it was worth with the defect. However, he was not liable for the added loss caused by the need to move, as it was not in a reasonable contemplation of the parties he would move so soon after the sale. Causation. This is a principle used in the assessment of damages for breach of contract or tort. Losses may have been foreseeable at the time of contracting or at the time of the breach of duty in the case of tort, but they will only be recoverable if those losses were caused by the breach of a contract or duty. The claimant must prove on a balance of probabilities that the breach caused the loss. It is not sufficient for the breach merely to provide the opportunity or occasion for the claimant to injure himself. The so-called but-for test used as primarily preliminary filter. If the loss would have happened in any event, then the breach would not be have said to cause the loss. As we mentioned, causation is an overreaching area of law which restricts the amount of compensation damages which may be recovered which arises from a legal wrong. It's one of the several legal filters which ensures that a defendant guilty of a legal wrong only pays for the loss for which they are legally responsible. The person who is legally responsible for the loss caused by the defendant in an unbroken chain of causation. In the law of damages, there is a marked distinction between causing damage in the colonial sense and assigning responsibility for damage in law. The next one is mitigation of damages. So mitigation of damages is a contract law concept that requires a victim in contract dispute to minimize the damages that result from a breach of the contract. This means that the victim is legally obligated to act in a manner that will mitigate both the effects of the breach and their own personal losses. If a victim does not mitigate damages, the court may refuse to award an exorbitant damages that could have been reasonably avoided by the victim. The court will evaluate the victim's actions following the breach of contract to determine if they took steps that a reasonable person in a similar circumstances would have taken to minimize their losses. However, mitigation of damages does not require the victim to take extreme steps or make substantial sacrifices in order to avoid or minimize losses. In contract law, mitigating damages will often involve making reasonable efforts to reduce losses resulting from the breach of a contract. For example, if a person is hired to perform a job and the hiring party cancels the contract in advance of the job, the hired party is generally expected to mitigate damages by seeking similar employment elsewhere if available. The duty to mitigate refers to a party's legal responsibility, as we mentioned, to make reasonable effort to limit the harm or losses stemming from another party's wrongdoing or negligence. This duty can apply in a variety of legal contexts, as we mentioned in tort law, in contract law, or in employment law. The principle behind the duty is to prevent individuals from exasperating a situation or doing nothing to prevent further damages than simply passing all the cost to the party that initially caused the harm. For landlord-tenant situations, this is an example for you. The duty to mitigate often does apply, but the specifics can depend on local laws. For example, if a tenant breaks their lease early, the landlord generally has the duty to mitigate damages by attempting to re-rent the unit. They can't just leave it vacant and then sue the tenant for the remaining months of rent. However, if they make reasonable efforts to find a new tenant but are unsuccessful, the original tenant may be still liable for the rent. Duty to mitigate loss. The claimant is not permitted to allow their losses to mount up. They are under a duty to take reasonable steps to reduce their losses, as in the case of Pearson and Saunders 1919. In this case, by the terms of a contract, the defendant was to deliver goods to the claimant on a monthly basis, and the claimant was to pay for the goods within 1 month of the delivery. The contract was to run for 9 months. The claimant received the goods at a discounted price because he had committed the purchase from the supplier over the 9-month period. The claimant was late in making the first instalment, and this amounted to a breach of warranty, not entitling the defendant to repudiate the contract. The defendant refused to continue with the original contract, but told the claimant that he would deliver the goods in future if the claimant paid cash on delivery, and would still let him have the goods at the discounted price. The claimant rejected this offer and purchased the good elsewhere at a higher price. He then sued the defendant, claiming the difference between the contractually agreed price and what he actually paid for them. It was held that the claimant was not entitled to damages. He was given the opportunity to purchase at the discounted price, but rejected this. He was under a duty to take reasonable steps to mitigate his loss. The offer was a reasonable one, and one which the claimant could easily have complied with. There are some common examples of mitigation of damages, and it includes things like employment contracts. So if an employer terminates an employee without cause, the employee is usually expected to mitigate damages by seeking similar employment. If the employee finds a new job at a lower salary, the original employer might be liable for the difference. Another example is lease agreements. As we mentioned earlier, the tenancy. If a tenant breaks a lease early, the landlord is typically expected to mitigate damages by attempting to re-rent, as we mentioned earlier. Another example, an interesting example, is construction contracts. If a contractor fails to complete a project as agreed, the property owner may be required to mitigate damages by hiring a new contractor to complete the work. The original contractor may be liable for any sort of additional costs that have been incurred. Another example is supply contracts. So if a supplier, again, fails to deliver goods as promised, the purchaser might be expected to mitigate damages by finding an alternative supplier. the original supplier could be liable for any price difference that has been paid by the supplier, the person, the purchaser. It all depends on the type of contract, terms, and the applicable law at that time. And you know, you need each case has its own area of law, but also it has its own issues around damages or mitigation or causation. So you really need to look at each case individually. So the references for today's session are listed there. So we've used Undue Influence and Unconscionability by Sweet and Maxwell, Beale, Contract Law, Anson, and Law of Contract, and Hart. And we've also used these following books, which is ATHE's Introduction to Law, which is quite an interesting book to have a look at, and McKendrick's Contract Law Text, Cases and Materials. Also, there is the Moodle resources that you can go on to have a look at learning outcome and look at damages in regards to mitigation, causation, and remoteness. And also, if there's any sort of additional reading, please go on to Moodle. Thank you for attending today's session, and I will see you in the next session.